mutual. So, I hope everyone's having a nice day. Actually, so in case you're wondering, I did have jury duty yesterday. I reported at 3 o'clock as I was supposed to. And as you may know, Texas trials take very little time. In state court, a trial's over and done in an hour. So by the time I got there at 3 o'clock when I was supposed to, there were no trials left for the day. So they sent us home immediately. So I was there for all of 15 minutes. They actually pay you $6 an hour, which I donated back to the state because I don't feel like paying taxes on it. It's actually more work than it's worth to collect $6, so I gave it to like some charity, whatever. But the actual process itself was over very, very quickly. All right. Let's see. Any questions? Anything on your mind? Yeah. I have a bad habit with that. You're learning, though. You're learning. You're learning. I appreciate it. You're learning at least something in this class.
Something.
Maybe not property, but hand raising. Yeah.
Just a review. I understand when it's community property jurisdiction, you can still do a joint tenancy where it has a.
If both spouses consent.
And that includes the right of survivorship.
Yes, sir.
All that stuff. And of course, assuming they do all the process. Otherwise, it's that quasi.
Yeah, and I'll recap. Again, I admit this is probably the trickiest. This is probably like the trickiest part of the entire class. If both spouses consent, they can create a traditional joint tenancy with survivorship rights. But unless both parties make that abundantly clear, it becomes a sort of community property quasi joint tenancy where the survivorship right does not exist. Make sense? Okay, very good. All right, so let's get started. We are actually moving on to a new topic. Here it is. I was looking for my seating chart. I was freaking out, and it was actually right here. So I'm actually good. I know your names, but not always correctly. So I do my best. Anyway, so I'm in good shape now. So we're actually moving on to a new topic today, which are leaseholds. Now, we spent a lot of time on what were called freeholds. These are the fee simple, the life estate, the fee simple determinable, the fee simple subject to blah, 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 right? We spent so much time on all these freeholds. Leaseholds are different. At common law, way back when, okay, the key differences between a freehold and a leasehold was that there was no livery of season, or season, if you will. Right? Remember, this is with the dirt and the twig and the twiggle. Remember that? This was meant to be some sort of temporary transfer of ownership of land. But I don't like using the word temporary because, as you can see, some of these leases can last 1,000 years, right? And that doesn't really seem temporary. And indeed, you can have what are called periodic tenancies, which can basically go on forever, so long as both the landlord and the tenant consent. So it's easy enough to call leases, temporary or a specific duration, right? But if it's done in a certain way, these things can go on for just about forever. Indeed, they can go on for even longer than a fee simple determinable or these other things where a condition might terminate the estate. So, although I'm sure everyone in this room has signed a lease, is that a fair assessment? Yeah, we all have. And it was probably maybe for a year or 2 years, whatever it is. Today we try to think of leases, it's for a year, 2 year, and done. But that need not be the case. The key distinction between freehold and leasehold is that it doesn't have this livery of season, this actual transfer of ownership. In other words, someone else always has some sort of predominant control. And indeed, it's not surprising that because there's a feudalism concept, it's called a tenant and a landlord, right? The lord of the manor. This is, we still call this person a landlord hundreds of years later, even though, this person's not a landlord. And if you recall the word tenant, was basically a synonym for like a serf, right? Someone who lives in the land. And I mean, the terminology we still use today, which you probably never thought of before, has its roots directly in this history. Okay. So a couple of things for you to keep in mind. One of which is when someone has a lease, there's always going to be a future interest. What do I mean by that? Property always must be accounted for at any given time. So say you have a lease now for a year. Okay, what happens after the year? Well, it goes back to the landlord. Okay, we're gonna finish up last time. All right, Brian, this is your review from last month, I guess. What do you think you call it if after the end of a 1-year lease, the tenant's lease runs out, it goes back to the landlord? What do you think you call that? See if you can remember. You can figure this out. It's not that hard, but it's you have to remember we did last month or whatever it was. I'm sorry? Oh, you made the mistake I told you not to make. You're so close. Reversion. See what he did, right? With a life estate, after the life estate, it goes back to the grantor. It's reversion. You did exactly what I said not to do. And I'm, again, not yelling at you, but students always want to do this because they go, oh, maybe there's a chance I'll go back, right? Possibility revert. No, it's reversion. That's correct. Yes, it's reversion. Yes, sir. Okay. All right, Matt, what do you think you call it if after I have a lease for a year and the paperwork says after I have a lease for a year, you get a lease for a year? What's your future interest then? Why is it a remainder? Bingo. Exactly. The terminology is the same from after life estates. In fact, as we'll see with the Gerrish case in a couple minutes, in some respects, the tenancy at will and the life estate can be very similar because they can effectively last the entire duration of a person's life. So you actually use similar terminology. All right, so any questions about the outset, just to bridge, last month and this month? You're gonna have to remember all this stuff for the thing coming up in a few weeks. I understand this is your property week of studying or something like that. This backwards. I never understood this. It never makes sense to me. What was that? Oh, this is appellate brief week. That's why there's so many empty seats, right?
Real quick, so when I said remainder, would I refer to that as vested remainder? Do I ever say just remainder?
Oh boy. So frankly, if it's a lease for a term of years, right? It's a 1-year lease, and it's going to end in 1 year. No ifs, ands, or buts. Then I think it's safe saying it's a vested. If it's a tenancy at will, where there's a process of whether both parties have to consent and one party has consent, there's been notice. You may not want to call that one a vested. Maybe it's contingent, but I wouldn't quite go there. Just say remainder, and I'll be happy. Okay. But your question is alluding to a very good one. But remainder is sufficient. Justin?
So I thought the question you asked was if a lease follows the lease, and so would that not be a contingent remainder because that person has to be alive to take the lease?
You're asking the same question he asked. I'm asking.
No, about the answer, I guess. Why would it only?
Well, no, my answer was don't worry about the depth, right? It's enough. It's enough to call it a remainder. Technically, the entire. I mean, we discussed this last time. Vested and contingent remainders, right? These aren't real legal concepts. These are just concepts to help you understand it. They're not actually real legal doctrines. So don't worry about applying them to leases. But the general gist is, at any given point, property must be accounted for, and either called a reversion or remainder is a good way to describe it. Yep. All right, Justin, you're up next. So, sir, tell me, what is a lease for a term of years?
It's an estate that lasts for a fixed period of time.
Okay. What does that mean for the estate lasts for a fixed period of time?
Basically, the lease says that it's for a certain number of years.
Okay. Which is after years?
No, it can be months.
Okay, good. That's what I was getting at. Okay. Even though it's called a term of years, it's somewhat misleading. It could be 6 months, it could be 20 days, it could be any period of time. So don't get tripped up if you see something that says a lease from O to A for 6 months. You're like, oh, what the hell is that? That's not a year. You can still have a term of years for less than a year. Term of years means a fixed period. And the book discusses some really crazy leases. There's just one lease involving Yale University for 999 years. So if you can fathom, the lease will run up in the year 2761. I guess we're almost there, right? But a number of jurisdictions uphold these sorts of 1,000-year leases. Far more common than a 1,000-year lease is a 99-year lease. So, for example, the Panama Canal was actually leased to the United States for 99 years. And recently, in the last decade or so, that lease ran out, and we handed it back to Panama. I think also, if I remember correctly, Hong Kong actually had some sort of a 99-year lease, and then it was returned to mainland China. Are you shaking your head? Is that right? Okay, good. Make sure I'm right. So you often have these 99-year leases. So all the people who made the original lease are dead, right? They're all long dead and gone. Kevin, let me ask you a question. Why would anyone give a 99-year lease or a 1,000-year lease rather than just selling it fee simple outright? Like, why would a property owner want to do this sort of 99-year lease and all this other stuff? Well, then why wouldn't he give like a fee simple determinable saying you can keep it so long as you maintain a certain use, right? Why would they do this sort of 99-year lease? I'll take a stab for that. Sarah, what do you think? Why would anyone do this sort of 99-year lease or God, even a 1,000-year lease, right? You know, the United States may not be here in 1,000 years, right? Yale University may be long gone in 1,000 years. Well, I mean, why would anyone do this sort of property transaction? Well, I'm sure there's a continual rent, but one of the bad parts of making a 100-year lease is you don't update the lease, and the rent value is not going to be pegged for inflation. So you're actually losing money. So whatever the rent was set in 17, whatever, 60, whatever this thing was, they're probably paying a couple pieces of silver a year. I mean, it's not a lot of money. So
maybe they don't have anyone in their family that they would like to actually designate it.
maybe Hunter, you seem like you want to answer this one.
Well, I mean, in situations like Panama or Hong Kong, you don't want to actually lose control of that territory, so you just lease it out, and other people can develop on it, build on it.
Yeah, but that's like a Panama Canal. Like, I'm talking about a farm in Connecticut. Like, what would an example be in a farm in Connecticut why you wouldn't just hand it out for fee simple?
I'm not particularly sure for that. I just think that
So do you want to take a step?
Isn't it just a way to avoid the rule against perpetuities?
Oh, it does that. It does. Why does it avoid the rule against perpetuities? Samuel, I guess, didn't raise enough money, so you have to. Oh no, I'm sorry, I'm in the wrong class. In my other class, in my con law class, one of the other property professors is trying to raise funds for a charity by saying she won't test and wrap. So they were trying to raise money in my con law class for that yesterday. Anyway, but that's a good point, right? This avoids wrap problems because it's a fixed term of years. You don't have to worry about the rule against perpetuities.
You eventually get it back.
Yeah, you get eventually whoever the remainder is, right? Whoever has the reversion. Anyway, there's not a particularly good answer to this. I think actually Hunter's correct. With big stuff like the Panama Canal, you eventually want some sort of reversion after it's been developed. But in terms of this, what's my answer? Because every year in this farm in Connecticut, they have this beautiful ceremony where they go and they deliver this it's like pieces of silver or something, right? And it's like a nice thing. And I think people want to just have the recognition, always being in charge, even though legally they don't. Now, there is one legal thing that does matter, something you'll learn about next term called covenants. A covenant is a restriction you can put on a piece of land to control how it's used. If you're the landlord, you can impose certain covenants on the land without your tenant's consent. You'll do this next semester. Don't even ask me about this. We do this next semester. So while fee simple determinable, the person with the future interest, the possibly reverter, can't do much. If you're the landlord, you can do extra stuff. But these 99-year leases are kind of silly, but people do them. Okay. That's about all you need to know about how to create the term of years. What becomes tricky though is terminating these leases. So the big question, and I'll go to no, that's, are you in the right seat? Oh yes, you are. Okay, Jose's out. Okay, yes, you're right. Okay. No, you're good. I skipped over a box. The tricky part with leases involves cancellation and notice. The biggest way that students get tripped up with this topic is when they have to provide notice to move out, right? You all probably know in your own leases you have to give 1 month's notice. That's correct as a matter of modern law, but there's common law rules as well. But with a term of years, Richard, how much notice must be given before you move out and before you vacate the premise?
Under common law says you have to give half a year.
No, a term for a term of years. Yeah. In other words, I say the lease begins on January 1st, 2016, and the lease ends on January 1st, 2017. Term of years, fixed period.
It's not half a year and it's not a month before.
How much notice is required for a term of years?
Is it a whole month before?
No. You want to take a stab, Julia? You don't. Yeah, right there. Zero notice. And this is just make this point again. It's not entirely full. The book doesn't actually say this so clearly, so I'll slightly slide a little bit. That's why I'm making this point clear now. With a term of years, where it's fixed from January 1st to January 1st, right? There's no doubt. There's no notice required to vacate. You're expected to get your butt out on January 1st. No ifs, ands, or buts, right? I guess. There's no notice requirements. So if you want to look on page 444, there's a problem. And just if you want, Frank, I'm sorry, Richard, if you want to read just the first sentence of 444 at the beginning.
On October 1st, L leases Whiteacre to T for 1 year, beginning October 5th.
Okay.
Following September 30th, T moves out without giving L any notice. What are L's rights?
Okay, stop right there. So how would you characterize in that first part, Richard, the lease?
So it is
For 1 year, beginning
term of
October.
years,
Yeah. Why is it a term of years? You're right.
because it leases in for 1 year.
Yeah, the key point is it's a fixed duration. It says right there for 1 year starting in October. So if it begins October 1st, when does it end?
October 1st the next year.
Bingo. So if the guy moves out on September 30th without giving any notice, is there any problem there?
No, that's fine.
Exactly right. Everyone see that? Right? Yeah, Justin.
So a lot of residential leases, like apartments and stuff, say, you have to do 30 days.
But it's not a term of years. It'll be like in the next sentence, which we'll get to in a minute. Okay? The phrasing, as with all of the various property conveyances we work with, the way the words are chosen is actually very precise. And after this class, you are all going to go home and read your leases again and say, oh, that's what Blackman was talking about, right? So you can then figure that out. Okay? So let's go into the next type of estate. The next one is the one that you're probably most familiar with, which is called a periodic tenancy. Okay? Julie, you want to tell me, what's a periodic tenancy? Okay, well, okay, good. So whereas the term of years is for 1 year period, no ifs, ands, or buts, the periodic tenancy is what you're probably more familiar with. And this is where it gets a little confusing, and and actually Justin's question was hinting at before. You can have a periodic tenancy that lasts a year, right? However, it's not actually a full year. It's a year, and at the consent of both the landlord and tenant, can be renewed for a second year. Everyone see the difference? A term of years is 1 year period dunzo. You can't ever renew it. With a periodic tenancy, you can have a lease from year to year. And you go from 1 year, and if, say, both parties consent, you go on to a second year, and then a third year, as long as both parties consent. Now, if one of the parties gives adequate notice, you terminate that estate. You terminate the lease. Or you can have a month-to-month, where it goes on for 1 month. If both parties consent, it goes on for a second month. If both parties consent, it goes on for a third month. It gets tricky when one of the parties wants to give notice. We'll do that in a moment. But the key fact is it can last a year, but because of the repetitive nature, it goes on periodically. Yeah?
Can you not do a term of years and then once your year is up, do another term of years?
You certainly can negotiate a new lease, but the difference here is you negotiate the lease once, right? You sign the lease the day you move in. And then unless either party objects, it keeps renewing automatically. Whereas in the scenario you described, with the term of years, you'd have to renegotiate new paperwork from scratch each year. The benefit of this is it's basically automatic. Unless one party comes in and gives notice that they're going to vacate, the presumption is it keeps going on and virtually indefinitely. This is why, in some respects, these periodic tenancies can last for a person's natural life. They can last a person's natural life. Yes, Crystal.
With periodic tenancy, because it is a fixed period involved, you have to wait until you at least do that before you give notice. Or it's
Okay, we'll do notice in like a minute. We'll get to notice in like 30 seconds. I'm really close. I just want to make sure everyone gets this part first. You're right in the next topic. You're right on target. But everyone get that. The idea that there are fixed periods. Okay? There are fixed periods. But they renew automatically. Oh, yes, sir.
For the fixed period, does it have to be based on a time frame, or can it be based on like events?
I'm sorry?
Can it be based on events?
Oh, I see. Like a conditional. We'll do an example like that in about 15 minutes. I'm going to hold it off, but short answer is yes. But we'll do an example like that in about 15 or 20 minutes. Everyone okay with this? Yes, ma'am.
I missed what you said. It can last for this natural life?
If it keeps renewing and renewing, it can last for the tenant's natural life. I mean, it can't go beyond the tenant's life. Once the tenant dies, the lease is void. And indeed, even if the landlord dies, the landlord's successor in interest takes over. So it can really indeed last for the person's entire life, unless either party gives notice. Now, usually when the landlord dies, the new landlord may try and give notice, which is what happens in the Gerrish case. Okay. Everyone, yes, Sarah.
You're saying that the tenant, if they die in a
Well, if the tenant dies, it's over. Like the lease is done. However, if the landlord dies, you can actually substitute the new landlord for the old landlord.
Okay. There's a sentence in here that said that death for a landlord or tenant doesn't matter for term of years or periodic tenancy, but I guess it doesn't make sense that a tenant could keep on going like they're heirs, I suppose.
A lease, I suppose you could inherit a leasehold, but that strikes me as fairly rare for that to happen. Because the entire nature of the lease, well, let me put it like this. The entire nature of the leasehold is that at the end of the next period, the landlord can come in and give notice to vacate. So even if perhaps even if the heir could inherit the lease interest, it only lasts 6 months to a year. So, I mean, because the other person will object to it. So I can't see that actually going on very long. Okay? But the key aspect you have to remember about the periodic tenancy is notice. So I'm sure all of you have had a lease and you understand that under the modern approach, you must give 30 days notice, right? Everyone, right? That's what, yeah, I've had it myself. That is not the common law rule. And this is actually one of those instances where the common law rule, which you have to know, is different than how things work in the modern day. So at the common law rule, if it's a year-to-year, if it's a year-to-year lease, you're required to give half of the period for notice. So if a year-to-year lease, you're required to give 6 months. If it's a year-to-year lease, you're required to give 6 months. So Daniel, let me ask you an example. Say the lease begins on January 1st. Okay? When would you need to give your notice by under the common law to vacate? And it's a year-to-year. Lease begins January 1st. When would you have to give notice by?
So by June,
Yeah.
the middle of the year.
Well, what date would that be? What would be the latest you can give notice? You're right, June. What? 30 days after. Yeah, right. June 30th. Exactly right. If it's a year-to-year and you give notice on June 30th, then you've given sufficient notice, and then you can vacate legally on January 1st of the following year. Now, Daniel, what happens if you give notice on July 1st, one day later? What happens? And what's the consequence of failing to give sufficient notice? What's the consequence there? Yeah, how long are you stuck in it then? Another year. So the issue with the term of years is if you fail to give sufficient notice, you're stuck for another year. So if you give it, I'll get to you in a second. If you give it on June 30th, you're covered. You're out after the end of the year. If you give it July 1st, it's too late, and then you're kicked over for a second year of the lease. Brian? If both parties agree, you can terminate any time. But the issue here is the landlord says, no, you're bound. You owe me rent, right? You got to keep paying up your rent money. This is always a dispute. The tenant, well, let me put it this way. It's usually the dispute when one party wants to get out and the other one doesn't. Either the landlord wants to kick out the tenant and the tenant doesn't want to leave, or the tenant's trying to get out early and the landlord's saying, nope, you're going to pay me rent. So the disputes here arise when only one party wants out. When both parties want out, they find a way to get out. That's not an issue.
For the 6-month marks,
Mm-hmm.
we'd said, the 30th of the month, as opposed to the 1st of the next month. But could someone argue that that's like kind of like a birthday, like January 1st and then July 1st?
Leap day thing, right?
Well, not leap day, but just like that. That is, I don't know.
The rule is half, and half of a year is 6 months, and January 1st to June 30th is 6 months, and July 1st is 6 months and a day.
I got it.
Right. I mean, so I know lawyers don't like counting, but at some point in your career, you have to count the statute of limitations. And if you blow your statute of limitations by 1 day, you're SOL. Right? It's an alternate meaning of statute of limitations, but you guys are SOL. If you know what that means, you look it up. Right? And by the way, you're also liable for legal malpractice. You blow your statute of limitation by 1 day. So make sure you file your stuff on the day it's supposed to be filed and not a day later, because then you lose your claim. Process matters. You may not have the correct winning argument on substance, but if you can win on procedure, you're just as good. And most lawyers don't appreciate that. But getting a case dismissed because your client blew a statute of limitations is worth it. I'll give you an example. There was this one case when I was clerking. There was an insurance dispute, and the amount in controversy was $75,000, 0 cents. And this went up to the district court, and then went up to the Court of Appeals. And none of the lawyers raised any objections. What's the problem here? It was a diversity case. And the amount of controversy was exactly $75,000 and 0 cents. What's the problem here? What's the problem here? How much were they short? Penny short. So you had this massive insurance dispute, right? And because the amount of controversy was only $75,000, 0, it was dismissed by the court. The court said, there's no jurisdiction, get rid of it. So neither lawyer on either side caught that. Or perhaps the plaintiffs knew about it, didn't say anything. But the defendants never caught it. So process, guys, is your friend. This is how you win stuff, when even if the law is not on your side, because procedure really matters. Okay. So that's if it's a 1-year lease under the common law. You need to give at least half the period, which is 6 months. Okay. But what if it's a month to month? So generally speaking, if it's a month to month, the rules vary. It's generally speaking, and this is not always, but what you're familiar with, it's generally speaking going to be a full month. Now, not 30 days, a full month. And you're asking, Josh, what's the difference between 30 days and a full month? So let me give you this example. Where am I up to? Okay, so Cesar. So what happens if your lease began on a January 1st, right? And then you give notice to terminate on, let's say, March 20th, right? So you give notice on March 20th. When is the earliest your lease would end? If you give notice on March 20th, would it end April 1st? When would it end?
At the end of April.
May 1st. Okay. If you give notice in the middle of a month under the common law, you still need a full month of notice. So say if you give your notice on March 20th, that doesn't get you out April 1st. That doesn't get you out April 20th. You need the full month of April to be valid. And then you get out May 1st. Okay. You may have seen this. I once had a lease. I was pretty sure I was getting ripped off. I didn't sign it. I tried to move in somewhere for a 3-month lease on like the 2nd of the month, and they wanted me to add a full additional month. I think they were trying to cheat me. I didn't take it. But I think it was based on this principle that it's a full 3-month, not like 2 months and 29 days, whatever it would have happened to be. In most states, and this is what you're all familiar with as a matter of modern law, it's a 30-day notice, not 1 month notice. It's 30 days notice. So you can actually move out in the middle of a month. You don't have to wait till the first of the month. You can imagine that is a very pro-landlord rule because it basically makes you pay an additional X number of days of rent. Okay. Everyone with me so far? Any questions on that? All right, Josh, you want to read we're still on question number 1, but the second what if. Over what if the lease had been T?
What if the lease had been to T from year to year beginning October 1st?
Okay, so what kind of lease we have here, Josh? Yes, sir. We have a periodic tenancy. Okay, how much notice is necessary for this sort of periodic tenancy?
Year to year at 4 years notice.
No, with a year to year, how much notice is necessary? We just discussed this.
6 months.
Okay, good. So when would you have to actually give notice to terminate on September 30th? Do some math. Boston's hate math.
It begins on the 1st and you want to get out on September 30th.
Yeah, so when do you have to give notice by?
In February. Or is it in March?
Well, you tell me. If you need 6 months before September 30th, September being the 9th month, so when would you have to give your notice?
In March.
March what? By what day?
Or March 30th.
Yeah. So by March 30th, you gotta give your notice. Okay? You need to give your notice by March 30th because you need 6 full months. If you do it on April 1st, too late. You gotta do it on March 30th. That's your 30 days, September, there's no 31, right? Yeah. March 30th, you have to give your notice. Okay? If you get 1 day late, it doesn't matter. Okay? Madison, what happens now if we're under the common law rule, right? We're under the modern rule. We're not under the common law. 30 days. When would you have to give it?
And it begins October 1st and ends October 1st, so you would have to notify them September.
Well, is it September 1st or is it August 31st? Which one is it? If you want to move out on September 30th, when would you have to give notice to get 30 days? Good.
The last day of
August
August.
31st. Yes, people. 30 days has to. Yeah, they're trying on your fingers, right? Exactly right. Okay. Under the modern rule, you have to give that notice by the 31st of August. Exactly right. Otherwise, if you wait till September 1st, you're bound. Okay. Yes.
So just for clarity, so I think you said, and I guess I just tripped up. So is it a month notice or just 30 days?
Well, in this case, it's the same.
Okay.
Well, I mean, in 30 days would be August 31st. This question makes it easy because it's the first of the month.
So let's-
But it is 30 days usually under the modern rule.
Okay, so it's like, if you want to know August 31st, then August 1st would be the day.
Yeah, yeah,
Okay, gotcha.
yeah. But in this example, happens to work out that it is in fact one and the same. Let's see, Rachel. You want to read the last sentence? What if the lease had been for no fixed term?
What if the lease had been for no fixed term at an annual rental of $24,000 payable $2,000 per month on the first of each month?
Okay, so this is probably not probably. You may have seen this in any kind of lease you have. Rachel, how do you think you'd characterize this? Would this be a term of years, or would this be a periodic?
I thought it was a tenancy at will.
Well, if you notice, we haven't done that yet in the reading,
Right.
so it can't be that. We haven't gotten there yet. In this page, we've not done the tenancy at will. So I appreciate the instinct. So among the two we've done so far, which one is this? It looks like a tenancy at will for sure, but which one among the two that we've done so far?
Periodic,
Okay, why do you think it's periodic?
because it's, that even though it says no fixed term, the rent's coming in on a periodic basis.
Yeah, and you're right. You may be inclined to say, oh, it's annual rental for 1 year, fixed year. But the fact that it has these phrase month to month, you're paying each month, suggests it's periodic. It's very often the case that the parties writing these leases are not sophisticated. And we saw this in the Gerrish case in a couple minutes. So a court will be more likely to read this as a month-to-month periodic rather than a term of years or even a year-to-year, right? The fact they say that the annual rental is $24,000, that's multiplication, right? They're just saying how much money is coming in total. But this is best viewed as a month-to-month periodic. Everyone get that one?
Sorry. In the previous one, the lease year to year, under common law, they would have to give notice on April 1st. I think it was March 1st, but then I'm trying to calculate.
No, in this case, if they want to vacate by September 30th, they need to give notice by June 30th. They have 6 months.
Where does it say that we have? Oh, no, I'm still thinking about the first part on the following.
Yeah, so September 30th. You got it?
Thank you, yes.
Everyone okay with that one? Yeah.
You said that the court will read it as a periodic tenancy, or is it just in this case?
I think there's a general presumption. Well, ask me that question after you do the Gerrish case because there are different presumptions. Courts read things differently. All right. Crime, you want to read number 2 for me, please?
The jurisdiction in question will stand prescribed in the method of terminating a similar tenancy. LLC from the rest of the months of December 2012 and January through March.
Okay. Very good. I'll come back to you in a second. So what often happens, right? This is actually a fairly common situation. Tenant vacates, and the landlord rents to someone else. And the landlord tries to double dip. That is, he's getting rent from one person, and he tries collecting back rent for the lease that was not voided correctly. This is, I mean, it's not common, but this does come up. So, crime at first, he gave notice on November 16th to vacate on November 30th, right? Under the common law, we'll start with common law, right? What's the amount of notice that he would have to give under the common law? Well, is this a year to year or month to month?
So it would be
Yes. And how many months? 1 full month. 1 full month. So Karaima, if the guy gives notice on November 16th, when is the earliest that he can then move out? No. Not 30 days. 30 days is the modern rule. 1 full month. If you give notice on November 16th, what is the full month that would have to pass by? The next full month. Why is it January? You're right. What's the full? Which is a full month? The entire month of December counts. The fact that there are 15 days left in November doesn't help you. You need the full month of December to cover, and then you can move out January 1st. She's exactly right. Right? Actually, December 31st, he'd have to move out. So he has to be out by January 1st. Everyone see that? Okay. Right. So let's see. So Samuel, he's basically on the hook for the rest of November and December. Okay. The landlord starts renting it in April. Is he in any way on the hook for what happens in April? Yeah. Why is he not in the hook?
Because he would have only had to pay through December, and then he's not on it from January on.
Good. So what is the only rent that the tenant here owes the landlord?
1 month's rent for the month of December.
Well, assuming he already pays November rent, which I think is probably true.
Yeah.
It's basically only December rent is owed. Okay. Everyone get that? You can't penalize a tenant if he had moved out properly, right? You can't penalize a tenant if he had moved out properly. Okay. Everyone get that question? Questions on this one? All right. Adam, you want to tell me about what a tenancy at will is?
So it's a lease that doesn't have a fixed duration, lasts as long as both parties consent to it in existence. And either party has the power of termination.
Okay, good. The tenancy at will, like Adam said, is so long as both parties are happy, it can go on indefinitely. It can go on indefinitely. Right? So that part is not complicated. The complication arises when what happens when the contract, the lease, says one party has the right to cancel. Does then the other party have the right to cancel? So imagine this situation, and this is actually what we have here. You have a lease where only the tenant has the right to cancel. The landlord has no right to cancel. Let's see. Thomas, what's the difference between a lease where only the tenant can cancel and a life estate? What's the difference there?
Doesn't the life estate policy?
No, if I say, look, I say, Thomas, I'm giving you black acre for life, right? You keep it till you die, unless you sell it to someone else, in which case your life estate, just keeps going on. I say, Thomas, I'm giving you a lease, and you can have it so long as you want. Until you cancel, you keep paying me monthly rent. What's the difference there? And assume you can't assign it. Assume you can't give the lease to someone else. Just makes it a little bit easier.
Is it because the tenancy will endures as long as the parties desire it?
Well, in this case, only the tenant can terminate it. The landlord cannot terminate it. What do you think, Norma? I mean, what's the difference, right? If only the tenant has the power to terminate. The landlord has no power to terminate. What? Yeah. Yeah, if the tenant stays there forever, it never leaves.
Is that the life estate person that's holding the life estate, if it can terminate until the end of the life, that person's life, and then tenancy at will, they can terminate whenever that tenant feels whatever.
Right, but even with a life estate, you can sell your interest in your life. Right.
Well, that means that the tenant doesn't have any control after they terminate.
Okay, good. So what we have here, right, the tenancy at will, and this is actually leading into the Gerrish case, is a situation where on the face of the lease, only the tenant has the power of termination, right? Only the tenant has the power of termination. And the courts struggle with this. Can it really be the case that the guy can live there as long as he wants? And under no circumstances can the landlord, give him notice to get out. Right? That's the issue in the Gerrish case. So you want to, Amala, you want to tell me the facts, please, in the Garner v. Gerrish case, please?
So this suit is brought by Garner, who is the executor of,
Executor. It's actually I'm glad. Executor usually refers to someone who actually kills someone, flicks a switch. Executor refers to someone who administers an estate. I realize it's a very subtle distinction, but and the words in fact are from the same root, and they're the same word spelled, but just the pronunciation. Executor, executor. Right? Just pro tip. Sorry, I didn't mean to interrupt.
and so Robert Donovan owned a house in New York.
Uh-huh.
And on April 14th, he released that to the tenant, Gerrish.
Uh-huh.
And on the tenant forms, it seems that there was an agreement that Gerrish had the privilege of termination of this agreement at
Okay, let's actually, very, very good facts, thank you. Let's actually look at the, I put the language of the lease up here. And the italics are the stuff they scribbled in by hand. So this is not an unusual case. You have two people. I'm guessing they're friends because this is a pretty sweet deal, right? This is pretty sweet deal for Lou Gerrish. He says, shall continue for and during the term of, and there was a blank here. So the person writing this form book probably thought, a year, 2 years, month to month. And they wrote quiet enjoyment. Now, that's a phrase which you haven't learned yet, and it's a phrase that makes absolutely no sense here. What quiet enjoyment means is that when you own a piece of property, the seller promises you that no one will come along and try and claim a superior title. So if I'm selling you Blackacre, I say, you know what? I'm going to promise quiet enjoyment, that no one's going to come around and try and say they own it. And if they do come around and say they own it, I'm going to defend you, and I'll, basically defend the legal claim, and that means usually paying you money. So the phrase quiet enjoyment has absolutely no relevance here, because a lease is not actually a transfer of ownership. So these parties are not sophisticated. But I think what they were getting at is the landlord saying, listen, no one's going to come around and bother you. You can stay here. And then it says, from the first day, May of 1977, and the term will end. And this part they wrote in by hand. Lou Gerrish has the privilege of termination, to be terminating this agreement at a date of his own choice. Right? That's the language we have here. So, Arusa, how would you characterize the language? What do you think the intent of the parties was here based on the language they chose? What do you think they were getting at? What do you think Mr. Donovan was trying to give Gerrish? Yeah, I mean, if you read the words and you read the intent of the parties, it makes it clear that he was promising Gerrish, look, I'm not going to kick you out. As long as you keep paying your rent on time, you can live here. If you want to move out, good. I'm not going to chain you here, but this is for you, Mr. Gerrish, right? This is yours. And in fact, later on, I think he calls him a Lou. I mean, it's a very informal document. I mean, these are probably friends, if I could guess. Okay, I wonder with that. But then, as always in this class, things go awry, and Mr. Donovan dies. And then, Pierce, what happens after Mr. Donovan dies?
The executor of the state brings a title to, I think,
quit, and basically evict Gerrish.
Yes, he's want to kick him out.
Gerrish says no,
You can't kick me out.
and so he sues him.
Good.
And in answering, Gerrish says he owes rent on time and that he had the right to terminate.
Very good. Okay, so we've studied so far 3 different kinds of leases, right? I told you the term of years, we have the periodic, and we have the at will, right? The tenancy at will. Traditionally, courts, when they're deciding these sorts of cases, are confronted with a choice. Which box do we shove this lease into? And it's sometimes the case that it doesn't quite fit in neatly. Maybe it's a term of years, maybe it's periodic, maybe it's a tenancy at will. What the court does here, though, is something quite different. They don't quite make, I feel like I'm in common law now, they don't quite make it up, but it comes awfully close. They develop a new type of estate to characterize what was trying to be accomplished here. Okay. So the first question that they're presented with, does this create a right of termination in the landlord and the tenant, or is there a right of termination in the tenant alone? So at common law, Florencio, at common law, if you had a tenancy at will, did both parties have the power to terminate?
Yes.
Okay, why was that the common law rule?
Because if the leasee had the right to terminate, then the leaseholder should have that same right.
Yeah, and there's actually an opinion by Lord Coke, who you should be familiar with. He was one of the most famous British jurists of all time. And it's spelled Coke like the soda, but it's pronounced Lord Coke. So if you ever say Lord Coke, people know you don't know what you're talking about. It's Lord Coke. You're welcome. Anyway, so Lord Coke was actually involved in the, if you remember the movie V for Vendetta, the gunpowder plot. He was involved in this trial, Sir Walter Raleigh, very, very prominent jurist. But Lord Coke effectively said, look, if one party has the right of termination, that implies the other one has it. Why? Because that would make it into basically a non-leasehold estate. If only one party could terminate, it becomes a life estate, and the person can keep it for life. And a life estate requires our favorite livre sizen, right? You need to actually transfer the twig and the dirt and the clump. Because there was no livre sizen here, the court will simply say, we will imply a right of termination on both parties. Okay, that was a common law rule. Now, Sarah, what does, I feel like we've had this lesson 5 or 6 times, what do courts today think about livre sizen, or season, if you will?
It's antiquated.
Antiquated, yeah. Do we want to stick with rules based on livre sizen anymore?
No.
No. So what does the court do here?
They say since the requirement for livery sizen is no longer valid, you know, like if nobody cares about that ceremony anymore, that it sounded like they wanted to go more to contract law, and if the parties agree to something,
good,
then we should honor it.
Okay, excellent. You said 2 very, very correct things here. So first of all, they get rid of this notion that we imply a right of termination both sides, because that is premised on livre sizen, right? The court's okay here with giving what amounts to a life estate to Mr. Gerrish, even without livre sizen. They're okay with that. But the second point that Sarah said is actually a broader trend in property law, which you'll see more next semester. In the 20th century, property law went closer and closer to the laws of contracts. Okay, why? Because contract has a lot of fairness built into it. Equity, you know, notice, consent. If you read through the restatement in the UCC, there's a lot of things about fairness. Property ain't fair, right? Property is not fair. If you have a fee simple determinable and you violate the condition, too bad. You lose your property immediately. I'm sorry, you know, you have to go through the process, but I mean, you lose your property, right? Contracts has mitigation and duties of care and all this other stuff, right? You'll see this semester and next, the courts start incorporating contract doctrine. And I'll get you a second. And the way they do it here is say, look, if the parties want to say that only the landlord, I'm sorry, only the tenant has this right of termination. Only the tenant has this right of termination. Then let's honor the intent of the parties, and let's grant it that only the Gerrish has a termination right. Yeah, Hunter.
I have a question about this tenancy at will. With the Gerrish case, the landlord would have.
Oh.
Terminate.
Oh, and the tenant can never terminate.
Right, and the tenant just decides to leave. What is the actual person sued for damages? Do they sue?
You know, I mean, it's a very good question. I can't imagine a court would ever uphold a lease where the tenant cannot leave. That amounts to, I think, slavery of some sort. I mean, I'm not exaggerating. I mean, if you actually sign a lease where it said you cannot leave, false imprisonment, I don't know. I mean, I'm trying to think without a kidnap. I mean, that can't be legal. So it's always the case that the tenant can walk. I mean, he's a free person. He can walk away. But the case here is, can only the tenant have the right of termination? And the court says that, yeah, sure. And then so the consequence here is, Carl, can the landlord ever kick out the tenant so long as rent's being paid? No, why not? Yeah, exactly. So long as the tenant keeps paying his rent and doesn't otherwise violate the terms of the agreement, right? You can imagine if he's loud or noisy or does something stupid, right? Brings a pet, whatever the lease says. But so long as the tenant keeps paying his rent, he's there for as long as he wants to be. There's no way to summarily give notice to kick him out. Isn't it though? Right? And that's what the court alludes to, right? The court creates this what the heck do they call it? They have a name for it. I'm drawing a blank on the name. I'm sorry. Yeah, that's it. I always forget the name because they made it up. It's not a real thing, but they call it a determinable life tenancy. Now, Carl, you're exactly right. Why does this seem like a fee simple determinable to you?
Because it has a duration.
Right. In other words, you can basically keep renewing this lease until you screw up and do something you're not supposed to, right? So the court actually uses this phrase determinable, and they call it a determinable life tenancy. That's not a real thing. And again, I feel like I'm a con law. I'm teaching Roe v. Wade later, but sometimes court makes stuff up, right? They made this up. They made up this estate. And there's actually a note after the case that discusses this principle of law called the numerus clausus. There's nothing to do with Santa Claus. Numerus clausus means that there are only a certain number of estates. There are only a certain number of estates that exist. And we have three types of leases. We have the term of years, we have the periodic, we have the tenancy at will, right? We've discussed these. Traditionally, courts don't make up new estates because it complicates things immeasurably. And the bewilderment on Carl's face is a testament to that fact, right? This is a new thing. This is basically a lease for life, if you think about it. But the courts, in this move to become more fair, said, let's honor the intent of the parties. And let's give them this sort of determinable life tenancy, whatever the heck they called it. Someone's going to ask me, is this the rule in any other state? I think the answer is no. But I'm pretty sure that Texas doesn't have this. Yeah.
So for to say this is just a minority opinion, this is not.
Oh yeah. This is. I knew someone was going to ask me that question in a few minutes. Okay, everyone with me so far? Yes, sir.
Related question, I guess. Earlier they asked what will courts like presumptively lean to?
Yeah.
Is there not really a clear?
Let me put it this way: the courts will try to presumptively lean towards something where both parties have a power of termination, and that could either be the periodic tenancy or the tenancy at will. What makes this case so unique is that the language demonstrates their intent to only give one party this thing. But the general idea, if you think about it, if both parties have a power to terminate, Sarah, what's the big difference between a tenancy at will and a periodic tenancy? If both parties have the power to terminate, what's really the big difference then?
I guess how much notice to give?
Yeah, the only difference becomes how much notice to give. If it's a tenancy at will, in theory at least, the notice is get out now at common law, right? But again, under modern approach, they still have a 30-day limit. So so long as both parties have the power to terminate, there's not much of a difference. The difference only arises here where only the tenant has the power to terminate. This is going to be rare. A landlord would be very foolish to sign this. I mean, I suppose maybe he doesn't know what he's doing, or he makes a mistake, doesn't have a lawyer, but these are going to be the rare cases, which is why they're in your book. The questions in your book are the weird, bizarre cases that help tease out a rule of law. Other questions on the Gerrish case, right? So here the court says we're going to affect the intent of the parties, and we are not going to read in a right of termination for the landlord. And here the landlord is screwed. Gerrish will be there till he dies. Yeah, Carl.
Sorry to be the dead horse. So,
That's okay.
So it's safe to say that when the terms of the contract are unambiguous.
Lease. It's not contract. Yeah.
The terms of it's unambiguous. The court's policy is to just uphold the intent of the parties.
Yeah. That's generally, I think, a good statement.
Where it's ambiguous, they lean towards something.
They lean towards both parties having this right of termination because that's generally what people understand the norm to be. Yeah.
Can the lease be amended, or
if both parties agree, of course. Yeah, I mean, these issues only arise when there's a dispute. If both parties agree, no problem. But here, Gerrish wants to keep paying his rent, and the landlord wants to toss him out. That's why this case goes on to court. Jamie?
You probably already answered this, but since this is a minority opinion where this doesn't control in another jurisdiction, if someone drafted a lease, they gave, for example, one party alone the right to terminate, in this case, I guess, like the tenant, would the court just invalidate that?
I mean, look, if it's a really clear lease, this is somewhat ambiguous language, but it was really clear that a landlord intended to give the tenant only this power. I mean, a court may give effect to that, right? I mean, it's not that this is a majority-minority rule, but if that's what the parties really want, I mean, you can imagine a situation where, a father gives to his old mother this lease for life, saying, Mom, you can stay here forever. You can imagine why parties would want to do this, and maybe it's as long as the mom keeps paying their rent, she can stay. I mean, who's charging the mother rent? I don't know, but you can think of situations where a party would want to do this.
So the fact that it's preventing them from calling it something decent. Is the fact.
Well, yes, and again, this is more of historical, right? At common law, leases didn't do a live rescisum, right? There's no clump in dirt. But today, there's still a difference between a lease and a conveyance of a fee simple, because even if you're selling land in fee simple, you don't need to give a clump of dirt, but there's closing, there's various procedures to go through the real estate transaction, which are necessary. Indeed, a lease for less than 1 year doesn't even have to be writing. The statute of frauds only covers leases of 1 year or greater. And the lease that you sign, however long and obnoxious it may be, is far less than the paperwork needed to actually convey a fee simple. And we'll talk about the actual form lease in a few minutes. I think we're okay with that. All right, let's go on to who am I up to? Okay, you're up next. Jose, you want to read question number 2, please, up there on page 448?
L leases Orange Acre to T for as many years as L desires. What estate does T have?
Okay. How do you think we characterize that one? Let's do a common law first, not New York. I think a common law court would read that.
That both would be a tenancy at will,
Good.
and both parties would have the right to terminate if one party has the right to both.
Yeah. At common law, this would be a tenancy at will. And even though it says that only for as many years as the landlord desires, I think this was Hunter's question before, that basically makes not a lot of sense that only one party has a common law, so then the other one would have it as well. Imagine the flip side, for as many years as the landlord says, well, that's slavery, so you can't have that. So both sides would have this power of termination. Now, under the modern approach in New York, I guess it's a life estate or life tenancy determinal, whatever the heck they call it, right? But under the common law, I think that's correct. It'll be a tenancy at will with both parties having the power of termination. You want to read Jeremy number 3? It's actually I think it's actually a Texas case in there as well.
For rent payments of $500 a month, L leases 3 acre T preservation.
I think this was the question that George asked me about 20 minutes ago.
What estate does T have?
Okay, so how do you characterize that?
I guess because.
Well, let's walk through this, right? Is this for a term of years? Is it for a set specific term of years?
I would say no, because the war is not.
Do we know when the war is going to end?
No.
Okay. Would this be a month to month or a year to year or periodic tenancy?
I want to say no.
Well, do we know how often it's going to renew?
I guess as long as the war is still.
Well, what about a tenancy at will?
Either party can terminate.
Yeah. So this is a difficulty that courts are faced with. This is the numerus clausus principle. It doesn't really fit into any clear box. It's definitely not a term of years, right? That I think we can scratch off. But I think Jeremy made a case, maybe it's periodic, right? And I think he also makes another case, maybe it's a tenancy at will because it can be terminated when the war's over, right? When the war's over, the landlord says, okay, war's over, scram. So I think this is probably better though as a tenancy at will. But it does have this sort of durational language that reminds you of the fee simple determinable. By the way, these were actually fairly common. You can imagine during World War II when all the people were sent abroad to fight overseas that you would actually sign a lease or someone saying, hey, you can stay here till the war's over and then I'll get my real tenant back, right? So these were actually done during World War II. Okay. You want to read, Cody, the second paragraph of Phil Pott versus Fields, actually a Texas case. Yeah.
So, what prevails? It would be just up to the court in that one?
That's how our legal system works. Whatever the court says, that's what it is, right? We're there for breakfast that they suppose. Right, but I think the better answer is a tenancy at will. And the key fact there is that both parties have this right of termination. You want to read the Phil Pott v. Field case, please? Just read through it. I'll stop you along the way.
Sure. Lease to T for a term of 20 years and so long thereafter as T moves the premises for particular purposes. Thereafter, the premises were used continuously by T for that particular purpose. L, sometime after the expiration of the 20-year term, was to terminate the lease. L argued that because the lease had an uncertain term, it was a tenancy at will, terminable by either party once the 20 years expired.
Okay, so here we have a situation, right, where there's a lease of 20 years, followed by so long as you use it for a purpose. So it's almost like a stacked will. You have a term of years, which is fixed, followed by immediately what I think would be a tenancy at will. That is, it could be canceled if some sort of purpose happens. Okay, so Cody, what happens here? What does the court do?
Court held opposite of what L wanted. Otherwise, although there is no definite ending date after the 20-year term, the date tied to the cessation of the use of the land for certain definitely ascertainable purposes. Common sense logic and the trend in the law support this decision. It appears that the parties intended to create a perpetual right to lease the land. When when the parties' intent is made clear, courts should enforce the agreement as written, even though perpetual rights are not there. No
Okay,
legislative-
good. So it's okay. So effective the court says here is we're going to give effect to the language. So the mere fact that it says you have a term of years for 20 years, and generally speaking, once the term of years is up, you can give notice, and you don't have to give notice, you just leave. Because they stacked it, the term of years followed by this durational, it's now considered tenancy at will, and the landlord cannot terminate it without the condition being violated.
And since the can't be terminated by either party, well, I guess it can be terminated by the lessee during the 20 years. It appears the whole time would be effectively at will, right? Doesn't make any
Yeah,
difference.
until the condition's violated, no notice can be given to terminate it. Okay, well with me so far. Okay. All right, so let's move on. And in our remaining time, we'll talk about the tenancy at sufferance. And this is something that you probably know as called a holdover. So have any of you ever held over on a lease beyond the date you're supposed to get out? None of you raise your hands. Okay, there you go. Did you get in trouble?
No, they just do what they stay here. They stay month to month.
Okay. I guess you're all more honest than some other classes in the past. So if you do hold over on your lease beyond the day, the landlord has a couple options. At common law, if you held over one day, he could come in, change the locks, and sell your stuff. You'll read a case about this next for the next class. At modern law, it doesn't work like that because of various protections for tenants. So if you're like Cody and you're trying to do things perhaps legitimately, if you decide to hold over beyond your landlord and you give the guy a check and then he decides to cash the check, that effectively creates a new periodic tenancy, what most people know as a month-to-month. If he refuses to cash the check, he can then move to evict you. But once he cashes the check or agrees in some fashion, you've effectively created some sort of new periodic tenancy. Now, how long is that tenancy? And this varies by state. So if it's month to month, can he then cancel it after 1 month or 2 months? Or does it create an entire new year lease? Some jurisdictions have very specific laws. So for example, California says the period is no longer than 1 month. But some jurisdictions say if you stay over by 1 month, like at the common law, you basically add another year, right? That's the question we did earlier. If you didn't move out by September 30th, you moved out October 1st, you're on the hook for a full year. Although, again, that's a common law. In most states, you're not going to look for the full year. As long as you give 30 days notice, you're only on the hook for another 30-day period. Okay. And more often than not, these problems arise from miscommunication or some sort of mistake. So usually people who don't move out on time, maybe they thought they had permission, or maybe they thought they got confused in the dates. So the law has developed to make this less harsh. That on on September 1st, whatever the day is, the guy can't come in and change the locks, or the guy can't come in and force him to a new 1-year lease. This 30-day period saying, okay, if there was a mistake, you're in the hook for 1 month rent, and then we'll move on with our lives. Okay. All right, so questions on that? All right, so this lengthy discussion about the difference between a lease and a rent and a contract, I'm not particularly interested in. The statute of frauds, which I'm sure you've buried in the deepest recesses of your mind, is actually fairly easy to apply in this class. A lease for more than a year must be in writing. If it's less than a year, you can keep it orally. And actually, I have the, if you want to look at it later, the Texas statute of frauds, which you may have seen, you may not have, I don't know. But if it's a lease, you can see what it says. A lease of real estate for a term of longer than 1 year must be in writing. If it's less than 1 year, it does not need to be in writing. I would strongly discourage you from ever doing an oral lease because you're going to get screwed. But write down your stuff. Okay. I do want to focus for a minute on this issue of form leases and bargaining power, because this is the topic that I find most law students don't fully appreciate. So I'll enlighten them. Did you discuss in contracts the idea of an adhesion contract? Contract of adhesion, the idea that in most cases when you go to sign a contract, you can't negotiate the terms, so you're stuck with it, hence a contract of adhesion, and that this often works to the detriment of people who perhaps don't have the means to negotiate better contracts. This is a generally familiar principle. So I'd like to give you the flip side to that. You're all going to be lawyers soon, and God willing, you all have clients, and the client will say, you know, I'm negotiating this contract with this other party. He wanted me to put these other terms in. I'm not sure about them. I want you to review them, right? And then you review this new contract, and then what do you send him? A bill. Yes. When legal advice is rendered and you provide legal advice, you charge someone. But I think I said this before. What's the most important aspect of being a lawyer? Most important thing. Did I say this already? Get paid. Get your bills paid. Because if you don't get your bills paid, you go out of business. Ethics, I mean, this is all really important stuff, but if you don't get paid, there's no food on the table. Okay? The lights go off and the rent gets, evicted. So it would be a wonderful idea if whenever you walked into a place to rent, if both the landlord and the tenant can negotiate at arm's length and make something a perfect, ideal lease for both parties, right? That would be awesome. But there's a cost. Every modification you make to the lease would have to be reviewed by their lawyers. While this seems like a good idea to make a little alteration here, make a little alteration there, that's expensive. And landlords don't just accept costs, they pass it on to the consumer. So were it actually the case that the landlord would make modifications for everyone, your rent goes up. A lesson which, if you learn nothing else from me, everything has a cost. Everything that makes things fair has a cost. Every bit of landlord protection makes rent higher. This is not a mystery. If you make something more expensive, the landlord spreads the cost. This is really basic economics. So the idea of this form of adhesion, I think, has always bothered me because it would probably be worse for the parties if they start making alterations. Think of the Gerrish case, right? Where you have these people who aren't sophisticated making changes and writing stuff in. This creates litigation, uncertainty. So as bad as form contracts are, as bad as form leases are, they probably eliminate litigation. They keep costs low, and in 9 times out of 10, they don't create a problem. Has anyone ever actually read their entire lease? It's a waste of time. Would you have not have, if there was this with a private party or a company or something?
I used to work in a tenant landlord law, so I'm very familiar.
Oh, so you were the landlord?
No, I worked for a nonprofit.
Right. So the question I always ask is, would anyone not sign a lease if there's a term there they didn't like? Would they move somewhere else? Maybe, maybe not. So it's funny. So Judge Posner, who I'm sure you all know, was giving a speech a couple years ago where he said he was buying a house and he didn't bother reading any of the paperwork. He said it was a waste of my time because if I didn't agree with any of the wording, would the bank have changed it? No. So what's the point? The only time you read is when you get screwed, and then you go and hire a lawyer. I haven't read any of my leases. It's just I sign whatever. Yeah.
Professor Carson says that we're supposed just to like write guys, scribble on the top,
And write in.
Not actually sign your name?
No, I mean you sign, but then you actually make sure that you know something. You add whatever you want. You just cross it
Yeah,
out.
I don't care. I'm a humble constitutional law professor. It won't matter. I don't read any of the stuff because it's not going to matter. Because if I disagree with it, I'll say, okay. Actually, I tried the very first, maybe the second lease I ever signed. There was some provision that I didn't like. I'm like, can I change? They're like, no. I'm like, what if I want to change it? You can go move somewhere else. I'm like, okay, I'm going to sign this because I need the apartment. Hunter?
Yeah, I'm just worried about the discussion of market forces being able to protect consumers.
I was going to get there next. You can talk about that. Go for it.
Well, my largest concern was what if the market isn't actually functioning? What I'm thinking of specifically is something like the proliferation of forced arbitration clauses.
Oh, well, tell your classmates about that. Much like the Panama Canal in Hong Kong, they may not be familiar with this.
I think we all saw a video of the reports.
Oh, so okay, so the idea of forced arbitration is like this. Do you know who made the video? Where the video came from? Do you know what the video was?
Hot coffee. It was about the
McDonald's.
McDonald's case, but it went into tort reform also.
Okay, so very often, this isn't so much for torts, it's more of a contract issue. But for example, when you sign a contract with AT&T for your cell phone, you basically agree that if there's any sort of dispute, the dispute will not be filed in court, but will be resolved by an arbitration, which is some sort of what's called alternative dispute resolution, ADR, if you know the phrase. A lot of people charge that these ADR proceedings are unfair, that the amount of money that they can collected is not high enough, and that this screws over customers, mainly because you can't engage in a class action, which is a large lawsuit that can help alleviate for a lot of people in a class. You can't do a class action arbitration. The flip side to this is that litigation is very expensive, and one of the ways that your cell phone company keeps the cost of your cell phone down is by signing these arbitration agreements. If they thought that every single dispute for your cell phone contract would wind up in court, they may charge you more for your cell phone. Whether this is a malfunctioning market, I'll let you think about. But everything has a cost, so that whenever you let someone go to federal court and perhaps sue with a class action, the companies will anticipate that and make things more expensive at the outset. Right? I mean, so you're going to get it on one side or the other, but there's a very vigorous debate on this exact topic. Okay. So questions on the contract of adhesion, the lease, things like this. Okay. I assigned a number of pages on discrimination. I'll say now, I'm not going to test you on this stuff. The reason why it's important, but the reason why I'm not going to test you is because it requires a fairly complicated statute, which the book gives very short thrift to. I think there's like 8 pages. You should take an entire class on discrimination law. This is a very important area of law. Civil rights discrimination is very important. And a lot of the stuff in this book, it simplifies to the point that it's not quite wrong, but woefully incomplete. There have been Supreme Court cases since then that have abrogated a lot of this. But the long and short of it is that the Fair Housing Act of 1968 prohibits a landlord from discriminating on the basis of race, color, religion, sex, or familial status. It only applies to landlords who have a certain number of units, right? If you're just renting a room in your back, in your basement, or whatever, you're not subject to these sorts of laws. This really only applies to larger landlords. The law has actually been expanded to cover not just those grounds, but also disability. This is now more broadly, and this is perhaps, the book does such a small job, it's almost a disservice. But there are generally 2 different ways of proving discrimination, not just in housing, in employment, and anything else. One way is what's called disparate treatment. Disparate treatment. Disparate treatment means you're being treated disparately or differently. You actually have to show that the person who discriminated did so because they were trying to treat you differently because of your status, your race, your religion, whatever. Evidence of actual discrimination is actually fairly rare. You would effectively need someone to say, I'm not going to rent, Josh's apartment because he's Jewish, right? You'd actually need specific evidence of that fact. For one reason or the other, people don't say things like that usually publicly. Maybe they do it privately, but they're not going to say that to you. And if you don't have evidence of it, it's hard to make that case. The alternate way of proving discrimination, this is what's alluded to in the book, is what's called disparate impact. Disparate impact. And this is actually statistics. You have to effectively show that even though their policy on its face doesn't have any sort of discriminatory animus, they're not trying to single out any groups, as a consequence of their policy, they're disproportionately burdening specific groups. They're disproportionately burdening specific groups. There was actually a Supreme Court case from Texas, God, decided, I guess, 6 months ago, or well, even more, almost a year ago, last June. I've lost all conception of time. From Austin. And the facts of the case were like this. The Fair Housing Office in Austin, whatever it was called, I can't remember the name of the department, used to give credits to certain low-income people to live in a certain, low-income housing. And the group charged that the city was only giving these sorts of credits for these poor people to live in the, downtown Austin area. And they weren't giving these sorts of credits to live in the, surrounding suburbs. And they argue that even though this wasn't designed, strictly to discriminate against certain races, it had the effect because most of the applicants for this affordable housing program were various minority groups of effectively ghettoizing or putting them all inside the inner city. In a decision that actually was surprising to a lot of lawyers, the court ruled that this case could proceed, that the sort of statistical evidence was sufficient to show a disparate impact claim. The case is still going on and there's other things, but the court allowed it. They actually referenced in the notes that there was this Mount Holly case from New Jersey that was settled. The case last year was a follow-up and actually resolved it. That was a very surprising outcome. That's all I want you to know about that stuff. It's good for you to read, and I encourage you to take a discrimination class, but this is such a small capsule, it almost does a disservice. Not quite, but almost. All right, questions on that? Questions on discrimination, on housing law? I'm sorry? You can answer whatever you want.
I don't know if it was better.
We got 2 minutes left, but you can do whatever you want. Go for it. You have the stage.
I'm wondering about the periodic tenancy thing. I don't know. I'm just thinking because it does involve the fixed term, and I know we did go over the notice, but like if you sign a lease for a year, you can't the next week
See,
your 30-day notice, right?
this is actually Justin's question before. You're not actually signing a lease for a year. You're actually signing for 12 one-month periods. There's nothing to repeat at all. You're actually not signing a lease for 1 year. You're actually signing a lease for 12 one-month periods. If you actually read the language carefully, it's not going to be a 1-year lease. It's for 12 one-month periods.
But well, I guess what I really want to know is you have to at least do that period before you can do notice. Right? Like you have to do that.
You need 30 days notice to terminate the lease. Although, but see, why this doesn't even matter is that most leases have cancellation provisions in them. Most say that if you terminate before 1 year, you pay a penalty.
Yeah.
That's not from the government. That's from the lease you're signing. Parties writing leases can always add additional terms. There's nothing wrong with that. So parties can make it even harder to terminate a lease than the state allows. Right? Parties can always agree to additional burdens. Norma, okay, anything to repeat or no? Siri, can we finish class? Yes. All right, we're done. Thank you very much. Have a good weekend.